Good afternoon, everybody. Welcome to WG University, Weber Gallagher's series of educational programs. This is our workers' compensation webinar series. I'm Jeff Newby, and I'm presenting today with Dave Green from our Philadelphia office. Each month, we present a topic in workers' compensation legal issues. We present both case law updates and ways to manage your risk in your business. And if you would like to view this webinar again, share it with others, or see our other WG University programs, please visit the Weber Gallagher website at www.wglaw.com, and you will find copies of this presentation and others under WG University. That's on the top right-hand corner of our website. Also, feel free to contact the firm with any questions at wglaw.com. And after today, you can also follow up with Dave and I directly because our emails are right at the top of the PowerPoints if you have any questions, and you probably will have some. So today's presentation is dual coverage issues. So we're going to be discussing New Jersey and Pennsylvania issues, crossing back and forth over the bridge. Next month, our topic will be MMI, cutting off temporary disability benefits, curative versus palliative treatment, and the timely voluntary tender offer. Those are New Jersey workers' comp topics that will be covered next month. So let's get started. Dave's going to kick us off.
Thanks, Jeff. A little background. When I started doing Pennsylvania workers' comp in 1991, I guess for maybe about 2 or 3 years, maybe 4, I was working also on New Jersey workers' comp. So while I admit that I have forgotten almost everything and can't even read a permanency chart anymore, I do have sort of an understanding of the issues in both states. And Jeff will tell you a little bit about his experience too, but it really helps to identify an issue spot when dealing with these multi-state jurisdictional problems. So with that as a backdrop of my background, and now I handle exclusively Pennsylvania workers' comp, Pennsylvania, there's 2 types of benefits, wage loss and medical. It's a form-driven state, so as those of you know who handle a lot of Pennsylvania workers' comp, you know that once benefits are initiated, it can be really, really tough to stop. The maximum benefit rate is very high. For 2017, it's almost $1,000, excuse me, $995 per week. MMI, which, as Jeff will tell you, has a huge effect in New Jersey, has virtually no effect in Pennsylvania. And really the only ways to stop Pennsylvania benefits without a judge's order, a particular form, or what have you, are threefold. 1, if the injured worker dies. 2, if the injured worker returns to work without wage loss, and even then you better get a document to help you to confirm that the benefits have stopped so there's no issue in the future if claimant leaves. And 3, if the claimant is incarcerated, but only post-conviction. So if the guy is sitting there in jail waiting to be sentenced for a year, or waiting to be convicted, you still need to pay benefits. So it's a very challenging endeavor in a lot of situations because once that flow of benefits start, both with regard to wage loss and with regard to medical, it's really an affirmative burden on our part to stop them, whether through job offers, through medical opinions, through some aggressive file handling that needs to be accomplished. Jeff, want to talk a little bit about New Jersey in general?
I do. And give you a little bit of background of my work. I had done Pennsylvania workers' compensation defense work for 20 plus years, argued in front of the Commonwealth Court, Supreme Court. So I have a lot of experience, but stopped doing it a couple of years ago. And the forms and WICAS is now all beyond me. I have those questions. I come to my Pennsylvania partners like Dave. And Dave, you were only in New Jersey for a short period of time, but you left a strong impression. There's some people that still remember you, taking no prisoners. Unlike Pennsylvania, New Jersey is a whole man state. It's a permanency state. It is not driven by temp. Temp is what drives the Pennsylvania workers' compensation system. It's how you value the cases. It's all about vocational rehab and getting people back to work. Are they making what they made before their injury? New Jersey is a whole man state, and so the benefits are somewhat different. Of course, there is temporary disability benefits, and that's for those periods of time where the petitioner is out of work and actively treating. So once they're done actively treating, as Dave referenced, the maximum medical improvement, the temporary disability benefits stop. And there's no petition, filed with the court. You don't have to ask the permission of the judge. You don't have to send a form to the injured worker to have them sign and agree. Totally different approach in terms of cutting off temp. Medical benefits are also provided in New Jersey, but in New Jersey, the employer, the carrier, controls medical treatment through the life of the claim. Assuming it's compensable, they've accepted the matter as compensable, they must seek treatment with your authorized physicians. And permanency is the third benefit. The permanency benefit is what drives 95% of the litigation in New Jersey. It's the brass ring. Temporary and medical are paid for and provided. There's no issues. Now they want that third benefit that they really aren't entitled to in Pennsylvania, but for specific loss, which are pretty rare, losing something for all practical intentions. So permanency can be, as you folks know that handle this, as small as 1% or 5% for an injured foot, ankle, a strained shoulder. But that's the extra benefit that they seek because you've already provided them with the first two. The duration of benefits is limited, as I mentioned, in New Jersey, because the injured worker only receives the wage loss and the medical treatment until they reach maximum medical improvement. Once they reach MMI, a plateau of recovery, any one of those synonyms you want to use, you're done with those first two benefits. At that point, temp and med have been paid, and now permanency is the only issue. And unlike Pennsylvania and all the forms, there are really no forms in New Jersey. There's the employer's first report of injury, which every state has, and that's filed electronically with the division. There's one other form that I never see anyone use, and it's supposed to summarize all the benefits paid. But generally speaking, when most of these cases go into some form of litigation, and when the case is resolved, the settlement form operates as that second form that kind of wraps up the case.
I really didn't even talk about the duration of medical treatment when I was talking about general information about Pennsylvania. But whereas in New Jersey, the employer controls medical for the life of the claim until MMI, in Pennsylvania, you only get to control, well, you technically never have full control, meaning the claimant can always go to whomever he or she wants, as long as he or she wants to pay for the medical treatment. At max, you have 90 days of control unless the claimant decides to stay with the panel doctors. And you only get those 90 days if you dot your I's and cross your T's, if you have a list of panel physicians posted in a conspicuous place, and you have the claimant sign the rights and responsibilities form, both at the time of hire and at the time of injury. It's not a frequent challenge necessarily once the person is at the panel. Typically, we don't see claimants' attorneys challenging that 90 days of control, but we definitely see after that 90 days, if the person is with a lawyer, the person immediately goes to his or her own doctor, unless the person is undergoing surgery with a reputable group or things like that.
And I should mention, I did mention the max rates. We talked about how temp drives Pennsylvania. Temp in Pennsylvania is also higher. The max rate in New Jersey for 2017 is $896, just about a full $100 per week less.
So the reason why we're here, and with that as a backdrop, is to really talk about dual jurisdiction. And unfortunately, it doesn't matter where we start paying benefits. When I say we, the employer through the insurance carrier TPA can initiate benefits in either state. But if the employee has dual jurisdiction, and there are many situations where that can occur, the employee has the protection of both states, and that's really why we're here, to try to talk about some of the ways in those situations that we can help try to minimize benefits. So in Pennsylvania, if the injury occurs in Pennsylvania, Pennsylvania has jurisdiction. It doesn't matter if the claimant is a truck driver who lives and works in Idaho and never drives east of the Mississippi, and one time the employer says, look, can you do me a favor? Can you just go deliver something at the Jersey Shore, and while driving through Pennsylvania is involved in an accident one time in a 20-year career of truck driving, that still confers Pennsylvania jurisdiction. You can also have Pennsylvania jurisdiction if there is an injury outside of Pennsylvania. But if the person's employment is what's called, in quotes, principally localized, as you see on the PowerPoint, in Pennsylvania, and generally we could have a whole seminar on that, but without getting into too much specifics on that, it's generally where the employer has a place of business in Pennsylvania where the employee regularly works at or from, or in the case of, for example, a truck driver, where the person might not have a principal place of business. If there is none, then where the contract of hire was made. That's generally the way Pennsylvania jurisdiction can be conferred if the injury does not occur in Pennsylvania.
Unlike Pennsylvania that has two statutes, the first one is Section 101. Any injury that occurs within PA's borders is covered by Pennsylvania's statute. And then Dave was talking about principally localized. That's a whole nother statute with subparts and parts after parts. It's very complicated, but it's statutory. New Jersey doesn't have a statute that establishes jurisdiction or when jurisdiction can be established.
Do you remember the section from your PA days for the other one? You remember 101?
305.2D.
Look at that.
Yeah.
305.2D.
Yeah.
Very good, Jeff.
I litigated a few of those cases. So in New Jersey, it's all case law based. So in New Jersey, similar to Pennsylvania, any injury that occurs in the borders of the state of New Jersey, they have New Jersey jurisdiction. If that's the only contact, that's enough. If the employee resides in New Jersey and the employer has contacts in the state of New Jersey, has business locations, that can be enough. If the employee is hired in New Jersey, that's enough as well. And when a substantial amount of the employment for the employer occurs in New Jersey, that's sufficient. It's all case law, and we could drill down a little bit more, but just briefly, where was the employee hired? It's old case law, and a lot of people don't realize it, but most contracts of hire are verbal. And where the acceptors or the person who accepts the job is speaking, where they are physically located, that's the state of contract of hire.
Same in Pennsylvania.
So,
Same rule.
so if the individual is standing in their home in Cinnaminster, New Jersey, and accepts the job offer from someone in Pennsylvania, the contract of hire is deemed to have been entered into in the state of New Jersey. And we ask in a lot of our cover letters when we get these files, give us the exact circumstances of the hiring. If they shook hands over a desk in Bristol, Pennsylvania, then we've got Pennsylvania jurisdiction for the contract. Residence alone is not enough in New Jersey. It's a factor, but in and of itself, it is not enough.
Same in Pennsylvania as well. And the contract for hire, just to back up, only confers Pennsylvania jurisdiction if the employee does not have a principal place of business. Principal place of business is the guiding force behind establishing what we call extraterritorial jurisdiction in PA, situations where the injury occurs outside of Pennsylvania, but yet there still is Pennsylvania jurisdiction.
Okay, assuming, and that's why we're here today, assuming the person has dual jurisdiction, they have concurrent jurisdiction, they can go for New Jersey or Pennsylvania. Both states have laws that prevent simultaneous receipt of benefits in each state. Pennsylvania, again, is by statute, Section 322, and New Jersey is by case law. So they can receive the same check twice. You don't pay the same medical bill twice. Those are obvious. But it's what overlaps and what seeps out the side is what we're trying to talk about today and minimize for you. So Dave's going to take it from there and talk about some flip-flopping of jurisdictional issues.
Right, and I have a number of clients who are involved in this type of situation, mainly trucking companies, and from listening to them speak, this is their pet peeve more than anything else. That just by virtue of circumstance, one person might be entitled to benefits in two states, where a similarly situated person might only be entitled to one state. It creates all of these issues within the company, exposure issues, all of those things. So the typical, actually, you're going to do the beginning of this, right? The typical scenario,
Yep.
And then I bounce over?
Yep. This is from New Jersey to PA. So this is a New Jersey to PA scenario. So in New Jersey, the injured worker has New Jersey jurisdiction, and they get temporary and medical benefits. And now remember, when New Jersey benefits are paid temporary medical, there's no official form filed. Pennsylvania has the TNCP or the NCP, or maybe an agreement for compensation or something, but there's a form filed. In New Jersey, oftentimes the employer, the carrier, the TPA decides the person was injured in New Jersey, we're going to provide them with 70% of their average weekly wage, we're going to direct them to the panel physicians. Or they were injured in Philadelphia, but they live, work, and the main office is over in New Jersey, so they're providing New Jersey benefits. Just because the employer and carrier decide that New Jersey is appropriate initially doesn't mean that's where it's going to stay forever. And they may be a completely correct and appropriate decision, and then the clients will come to us and say, but they're going over to Pennsylvania. We picked this up in New Jersey, and I'll tell them, you didn't do anything wrong. They're just exercising their concurrent jurisdiction rights. they can go over to Pennsylvania because they were injured at 20th and Market. So, they can switch their jurisdiction. And what happens is, typically, the petitioner receives their wage benefits, they receive their medical treatment, they get to maximum medical improvement, and let's say it's a scenario where there is permanent light duty restrictions and the employer cannot accommodate them. Their check disappears for wage loss, their medical treatment ends, and they drive up Route 95 and they see a billboard. And they call that billboard.
And there are many.
And there are many. And they call that attorney and say, hey, I got injured at 20th and Market. I mean, I live in Jersey and I work out of Jersey, but I got injured at 20th and Market. I have no job to return to, got no temp, and they said I'm MMI, so I've got no more treatment. What can you do for me? And the attorney's going to say, I got you. You were injured at 20th and Market. You're going to get benefits in Pennsylvania because you have Pennsylvania jurisdiction. And there is no such thing as MMI. So I'm going to file a Pennsylvania claim petition, and Mr. Green's going to have to defend it.
And so a lot of things happen at that point. And maybe it's a good time to talk about one quick defense, even though, as I have on this page, there is no defense to Pennsylvania jurisdiction. There could be a defense to the nature of the injury, and that's the beauty of the lack of forms in New Jersey, because sometimes, and Jeff can correct me if I'm wrong, sometimes the authorization of treatment is liberal in New Jersey, because if you think the person only injured his or her low back, but the person's complaining of a little bit of neck pain, well, maybe you'll provide the authorized treatment for the neck because it's not a big deal. You haven't necessarily accepted the compensability of the neck by virtue of providing that medical treatment. So because there are no forms in New Jersey and because there are forms in PA, just because authorized medical treatment has been provided, and I've even had cases where sometimes even though a claim has been sort of, oh, we'll accept it, we'll give the medical treatment because they don't feel like it's that big of a deal or even worth their while to deny it. Whereas if that case were in Pennsylvania, who knows, maybe there would have been a denial because of the questionable nature of the claim. But assuming a compensable injury without question, there's no defense to jurisdiction in Pennsylvania if the injury occurred in Pennsylvania, as we've already said. And the employee can go and see his or her own doctor now in Pennsylvania. And the question is, what else can you do? So there is no defense to medical, as I indicate, although once jurisdiction has been established via bureau document, a utilization review can be filed. And that's where it's very important to not just look at what treatment was authorized in New Jersey, but really now take a harder look at what the compensable injury truly was, because you're going to want to file a bureau document, and you have the right to control what's on that bureau document. Secondly, even though there is no defense to medical, there can be a defense to wage loss. Now, it's important to know that judges differ on this, and there's no case law. So two scenarios. One, if a job has been offered in New Jersey that pays the pre-injury average weekly wage, you can argue that even though we're required to pay for reasonable and necessary medical treatment in Pennsylvania, that we're not going to voluntarily pick up a wage loss claim, and that it's the employee's burden to establish total disability benefits or compensable wage loss. Like I said, there is no case law. It is a judge-by-judge situation. So you may have one judge who says, and I've won cases like this, where we have denied the entitlement to indemnity and the judge has found no wage loss. And I've been in situations where the judge has said, look, Mr. Green, you need to pick up this claim and file a petition for suspension and try to get the wages cut off. Point being, you need to use any possible weapon in your arsenal. So if you can, if there has been a job offer made, then you deny the wage loss claim, and at least it goes before the judge and you're going to get an idea of what the judge's viewpoint is on this particular issue. Same situation if in New Jersey you have a 0% permanency award or an opinion of full recovery. You argue that there's no additional wage loss that can be paid. Now, I don't think in that situation, I think it would be very dangerous to take the position that because you have a full recovery opinion in New Jersey for a compensable injury, you can simply not pay meds. I think that would be a very dangerous position to take. I think a better position is file a utilization review and don't pick up the wage loss. But I have had clients who have said, look, we're going to take an aggressive position on this. And this is just the way you need to analyze these cases. You need to figure out what the issues are, what your potential defenses are, and use them to the best of your ability. And the last bullet that I have on here is really the most important one. And that is just be cognizant of that case where you are paying New Jersey temp, where you're managing the case under New Jersey law, but you know the accident occurred in Pennsylvania, because maybe there are some things that you can do, like the job offer, trying to get a zero permanency, whatever it is, to hopefully put you in a position to defend in Pennsylvania if the case comes over there.
And Dave, just to go back a little bit, just to what you were talking about in terms of when the claimant's firm comes barreling into court in Pennsylvania and says, Judge, my client is not working, they're still treating, or maybe they're done treating, but the doctor who cut them off in New Jersey said they're not fully recovered. I just can't do any more for them. Be aware that oftentimes you're also going to get the penalty petition.
True.
And I've had those before, because back when I did PA Comp, I defended some of these cases, and I've always been able to argue to the judge successfully. The carrier, the employer, did nothing wrong. They paid all appropriate benefits in New Jersey. But what you need to do in order to avoid penalties being assessed and counsel fees is make a very quick decision with advice of counsel whether or not you're going to pick up those Pennsylvania benefits quickly. The more quickly you pick them up, the judge of compensation in Pennsylvania is going to say, Counselor, this was a New Jersey case legitimately. They meet the New Jersey requirements. They did everything appropriate, and they cut off appropriately, apparently under New Jersey law. As soon as your client decided to switch states, they looked at the file and they immediately picked up on the Pennsylvania.
It's a good point, and you're going to have to pay back benefits using the maximum rate example. You're going to owe back TTD for the max rate, for the difference between what was paid in New Jersey and what they're entitled to in Pennsylvania. You can still make the argument that they're not entitled to any future indemnity if you have a defense. The other situation where the penalty petition is filed is, there wasn't a bureau document filed. And again, same situation. I've never been in a situation where judges can do what they want, but I've never been in a situation where a judge has awarded a penalty because you have administered the case under a jurisdiction where there is valid jurisdiction.
Right. So, yeah, the claimant's attorney likes to argue that we violated the statute by not filing an NCP when there was legitimately an option between the two states. And of course, they're going to say, well, you chose New Jersey because you got control of treatment. Maybe we did, but we were permitted to because New Jersey jurisdiction applied. As soon as your clients shifted states, we looked at it, we agreed. So just try and move quickly on those issues. So let's flip this scenario. So let's say the benefits start out in Pennsylvania. So you guys pay temporary and provide medical treatment in Pennsylvania. And let's say that injured truck driver recovers and goes back to that high wage earning job because there's no reason for them to stay out. They're making too much money working, so they don't want to stay out long in Pennsylvania. They're able to get back, but they have an MRI that shows 1 or 2 level disc herniations.
Or the employer has a dispatcher job available that pays the pre-injury average weekly wage.
So they come back to work. And let's say in Pennsylvania they come back to work after a cervical injury, a couple of disc herniations, and they're out for 6 months. That's it. They get their $800, $900 for 6 months. Medical's done. They're like, that's it. I got an MRI that shows a herniated disc, and I'm not getting anything else. Again, maybe they see the billboard. They get the advice from counsel that says, while the accident took place outside Harrisburg, your depot is in Pennsauken, and you live in New Jersey, and you can get this thing called permanency. Can't get it in Pennsylvania, but you can get it in New Jersey. So then they file the claim petition in New Jersey seeking jurisdiction over here. They would have it, and we would just argue for credits, which I think we'll get to in a second. But what we want to talk about now is balancing off any potential settlement that may have occurred in Pennsylvania and really trying to head off any potential settlement in Pennsylvania. If you know, and you can tell by looking at the file or seeking advice, that they have concurrent jurisdiction, you don't want to settle that Pennsylvania case for compromise and release without your eyes wide open about how you want to limit your exposure in the state of New Jersey. Dave and I were talking about this beforehand, and we've discussed it sort of in the past. Any language that's in a compromise and release document that says this settlement provides benefits in a lump sum for Pennsylvania benefits, and it also closes with prejudice their entitlement to seek any benefits in New Jersey. That is not binding upon a New Jersey court.
Even if it's a general release where you have separate consideration outside of the Pennsylvania compromise and release, it's up to the Jersey courts whether or not they are going to enforce that. And my understanding is that they might, but they have no obligation to.
Correct. Yeah, it was in the second PowerPoint we have, again, unfortunately, we've said this a few times today, no case law on this topic. Eventually there will be case law, but thus far there is no case law on the topic of what are the credits relative to a compromise and release versus a permanency award versus a Section 20 award in New Jersey. I had a case where I thought the Pennsylvania Defense Counsel did one of the best jobs I've ever seen in the compromise and release, where the language was very clear that the settlement of this case contemplated a waiver of all future benefits in the state of New Jersey. They did as good a job as they could. They probably could have thrown in a few more statutes, et cetera, but they did a pretty good job. Despite that language in the compromise and release, they came to New Jersey, filed a claim petition seeking permanency, and they'd gotten maybe a six-figure. It was a large CNR in Pennsylvania. Of course, I got the documents. I presented them to my judge, and I'm usually pretty calm, but when people do that kind of stuff, it infuriates me, and I was a little hot under the collar. And my judge didn't really appreciate the fact that the person did this. And they said to me, Jeff, I'm not bound by this Pennsylvania document, but counselor, I'm not going to provide your client with any award for permanency until the employer in this case has received a full credit for the CNR dollars. That was his perspective. He said, take me up on appeal if you don't like it. We were able to get a nuisance value dismissal under Section 20. And I argued to that judge, and I've argued in other cases and will continue to argue, that while the compromise and release is a lump sum of future wage loss, whether it's
and medical,
whether it's usually not sum total. If you're settling it, you're usually agreeing that they are employable, usually, that there's some earning capacity.
Maybe.
So it's a future lump sum of benefits that they could get, and you're accelerating paying it today. New Jersey, the permanency is future loss of function. And the future loss of function, we pay permanency, and Dave, you may remember this, every 4 weeks. We don't pay it in a lump sum. Mm-hmm. It's paid akin to wage loss. So I argue to the judges, the theory behind it is the person is not supposed to be 100% anymore. That's why they're getting some loss of function. So my argument is, if it's future loss of function and there's some bleed over into how it may affect their ability to earn income, that they are similar enough that there should be a full credit. Again, there's no case law on it, but those are the arguments that we make to try and make sure that you don't have to pay a full CNR and then face full exposure in New Jersey for permanency. And my next thought on this topic was, if they come over to New Jersey and they want permanency, and let's say you didn't get a full CNR in Pennsylvania, I would insist, and I will insist, that they get me a maximum medical improvement report from the treating doctor that they've decided to choose to treat with, because in Pennsylvania they've had that option. I want a report from that doctor saying they have reached maximum medical improvement and they're at a plateau of recovery. At that point, permanency becomes an issue in New Jersey. Before then, I would argue to the judge, and the judge would agree with me, I don't need to schedule a permanency evaluation. So then we'll get that MMI report from the Pennsylvania doctor that they have gone to and use that the best we can and to leverage both of our states for medical exposure.
And I know you and I have done this before. If we know that there is a New Jersey jurisdictional component to a case, we've talked about saying, let's just make sure we get an opinion of MMI in PA before we settle that case. Because maybe all of the benefits paid after MMI, if you have that opinion, maybe a judge of compensation in New Jersey will be more apt to try to use that CNR as a credit, even if that language wasn't in there. And maybe it's a good time to talk about this, but when we have these situations, and there's a Jersey component, for example, in the scenario that Jeff talked about, where there's New Jersey temp being paid, person is at MMI, stops receiving temp, comes over to Pennsylvania, that there is a New Jersey permanency lingering in the background. So when you go to the mediation in Pennsylvania and you're talking about settling the case, and you're talking about big dollars, a six-figure settlement, you say, look, this has to include any sort of Section 20 settlement in New Jersey. And Jeff can talk about it more, but I think that most New Jersey judges of compensation, assuming the amount of money being paid in Pennsylvania is enough, are more than willing in that situation to allow a modest Section 20 to $2,500, $5,000, where we just portion out 2,500 or $5,000 out of the big Pennsylvania CNR, which is then paid in New Jersey.
Right. And we've done that successfully a few times in the past, and it's one of them was very entertaining, where the injured worker was in court in Upper Darby in the morning and got their CNR and drove over and met me in the afternoon and got their Section 20 simultaneously on the same day.
Which is the better way of doing it. You don't want, you want those things to be as quickly as possible, because you don't want to pay one without paying the other. And you want to put the language in the CNR agreement that the settlement of this is contingent upon claimant proceeding in New Jersey with the Section 20 settlement.
Right. And as Dave said, we're trying to leverage the best results we can for you. So we'll seek all the credits that we can. So you mentioned, a maximum medical improvement opinion from a doctor in Pennsylvania. We can argue, and the judges don't have authority in New Jersey to give us credits for overpayments. The best one that they will do is if there's a return to work and the person continues to get paid. Then they're not happy, because then they'll call it unjust enrichment and say, even though I don't have the authority, counselor, you representing the injured worker should know they can sue your client and go after them in civil court. So why don't you just give them the credit off the permanency? After MMI is a little bit hazier. The judge is going to say, well, you paid after MMI. That's not, that's not their fault. They weren't back to work. But in a situation where you're paying benefits after MMI because it's a Pennsylvania issue, the judge may be a little bit more offended and say, you saw Pennsylvania benefits. You got temp long after you would have gotten it in New Jersey. It may come into their thinking with respect to the permanency award now to get it some kind of credit. And in addition to the difference in the temp rates, I may argue that $100 more they got in Pennsylvania temp, when I do stipulations to settle a New Jersey case, I talk about the rate that was paid. I'm not going to say $996. There's no such thing as $996 in New Jersey. So I would tell the judge, they got $100 extra a week. If they now want you, judge, to approve this permanency award, you should also recognize the fact that their temp was higher than it should have been under our state law. Whether or not that works, again, there's no case law, but we make those arguments.
Right. $995, by the way.
$995.
All right. So this is really where this stuff comes most into play when you're trying to settle these cases, because that's, we're always trying to get closure for you as soon as we possibly can. Oh, I'm sorry. So you always have to make a tactical decision as to whether to settle both states when settling one. The situation I gave before is kind of a no-brainer, where the person might even have a lawyer in New Jersey already. But sometimes you just are aware that there's New Jersey jurisdiction and you're settling the case in Pennsylvania and you don't want to raise the issue. Same thing, especially in New Jersey, going over to Pennsylvania. And it just has to be a tactical decision, because as long as you know the risks involved, then you can make a tactical decision based upon those risks. We talked about the next bullet point about the Section 20. We talked about some New Jersey judges will allow for a credit. The last one is actually a case that Jeff and I handled together, where Jeff had the New Jersey component and I had the Pennsylvania component. The case is still ongoing. It was a situation where the claimant petitioner, I guess in New Jersey, had received a permanency award for a left hip injury, and that permanency award was being paid out over time. The person was back at work, suffered a new injury, and was receiving the max rate for that injury. Well, when the file came to me, I petitioned the court to have the Pennsylvania TTD reduced by the amount of permanency that the employee was receiving, because the aggregate of the weekly benefits between the permanency in New Jersey and the TTD in Pennsylvania exceeded the max. And the judge initially gave us relief through supersedious, but then turned it around at the time of the decision, which was sort of bizarre. But the point being is, all you can do is make the argument to the best of your ability. There is no case law on it, and at least for a while we had some decent relief.
And simultaneous with the judge's decision to grant supersedious that on a partial basis in Pennsylvania, I got a letter from the New Jersey attorney saying, your client doesn't need to continue to pay that partial. You can suspend that for a while. And I said, no, I think we'll continue to comply with the court order. And referring just for a second to Dave's reference to Section 20 and why it does work in New Jersey, we're kind of roughing around the edges of a Section 20. in the statute, you can Section 20 a case lump sum with prejudice, a case that's denied for causal relationship, dependency, and jurisdiction is one of the grounds. Now, these scenarios, we're saying they have jurisdiction in both states. So my argument to the court is not so much they don't have jurisdiction, but there are jurisdictional issues. And by and large, the judges have said, you have an issue of jurisdiction, Pennsylvania, New Jersey, I will allow a Section 20, even though you can see that New Jersey probably is appropriate for New Jersey. So we can get it, because the confusing issues such as medical care and how to pay a medical bill, as the bills come in, do you do Medicare, Medicaid gap guidelines under Section 314, or you do usual and customary under the Jersey statute? It would be a different payment. So that's why the judges are oftentimes, I'll Section 20 this because of that concurrent jurisdiction issue. Oh, I think we're good.
You have anything else on that one? This one.
Let's see. Yeah, I think we've kind of said this a few times. If we can settle cases simultaneously in both states, let's do that. But as Dave did point out, if you want to leave sleeping dogs lie, just do it with your eyes wide open. If you want to leave the bear alone in Pennsylvania and you've resolved the New Jersey case and there's been no rumblings of a Pennsylvania case, then by all means, every once in a while you can just walk by it and it may never appear. You don't have to necessarily go looking for a fight. But if you know it's coming, then sometimes it's much better to just face your fears, get rid of both cases simultaneously.
And this is really the wrap up. It just really recognize when dual jurisdiction applies that there's no real case law. So just think about the situation, speak to your attorneys, conference it in-house, and just make good decisions on what to do, because the employees are entitled to the benefits of both states if they meet the dual jurisdiction requirements.
Anything else?
That's all I have.
All right. Well, thank you for attending our webinar today on dual coverage in New Jersey and Pennsylvania. As I mentioned earlier, our next program is going to be on June 20th, and that'll be from our New Jersey office. You should have come over to New Jersey today. I battled bridge traffic. And that's going to be MMI, cutting off temp, curative versus palliative treatment, and a timely voluntary tender offer. So our New Jersey attorneys are going to tell you how to analyze a claim to establish initial file reserves, updating the reserves as information comes in and potential exposure throughout discovery, and explain various factors that affect the settlement value of the cases throughout the state of New Jersey, because as you know, there's different settlement values from Newark to Atlantic City. They'll also discuss the right time to make a voluntary tender offer in those cases where maximum medical improvement has been elusive and it's been hotly contested. When's a good time to put your feet in the ground or plant feet in the sand or whatever, cut off the medical intent, and then flip it to a voluntary tender. So they'll be talking about that next month. And you can learn more about that program and other events that Weber Gallagher puts on, again, at wglaw.com/WG-University. Thanks, everybody, and have a great afternoon.
Yeah, thanks for joining us today.